Procession of the Court Orderlies.
Procession of the Chief Registrar and the Registrars of the Courts.
Procession of the members of the Malaysian Bar. Procession of the State Court Directors. Procession of the Heads of Division and Deputy Heads of Division of the Attorney General's Chambers.
Procession of the President of the Malaysian Bar, President of the Sabah Law Society, President of the Advocates Associations of Sarawak. Procession of the Attorney General of Malaysia, Solicitor General of Malaysia, Attorney General for the State of Sarawak, Attorney General for the State of Sabah, and Solicitor General too.
Procession of the Judicial Commissioners of the High Court of Malaya and the High Court of Sabah and Sarawak.
Procession of the judges of the High Court of Malaya and the High Court of Sabah and Sarawak.
Procession of the Judges of the Court of Appeal.
Procession of the Judges of the Federal Court.
Procession of the Right Honourable Chief Justice of Malaysia, the Right Honourable President of the Court of Appeal, the Right Honourable the Chief Judge of Malaya, and the Right Honourable the Chief Judge of Sabah and Sarawak. Honorable Judges, Your Excellencies, distinguished guests, ladies and gentlemen, the national anthem, Negaraku. Ladies and gentlemen, please take your seats. We now invite Mr. Muhammad Dini Shazwan Abdul Shukur, Senior Assistant Registrar, to lead the Doa recitation.
Assalamualaikum warahmatullahi wabarakatuh. Let us begin our dua with the recitation of Surah Al-Fatihah. A'udzu billahi as-sami'il 'alim. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Ya Allah, kami mengangkat tangan memohon perkenan dan rahmat-Mu agar Engkau tambahi kami dengan ilmu dan pengetahuan. Engkau angkatlah darjat Badan Kehakiman dan Perundangan di negara ini sebagai institusi yang disegani, diyakini, lagi dihormati. We humbly ask from you, O Allah, for all goodness in this auspicious day, its opening and its light and its guidance, and we seek protection by you from its harm and mischief. O Allah, make our gathering today a blessed one, and our disperse thereafter with your forgiveness. Allahumma khtim lana bihusnil khatimah wa la takhtim alaina ya Allah bisu'il khatimah. Wa sallallahu ala sayyidina Muhammad wa ala alihi wa sahbihi wa sallam. Walhamdulillahi rabbil alamin.
Thank you, Mr. Dini Shazwan.
Honorable judges, your excellencies, distinguished guests, ladies and gentlemen, we now present to you a multimedia presentation entitled Reminiscing Memories of 2024.
honorable judges, your excellencies, distinguished guests, ladies and gentlemen, the Right Honorable the Chief Justice of Malaysia will now preside.
I invite Mr. Muhammad Azri bin Abdul Wahab, the President of the Malaysian Bar, to deliver his speech.
Assalamualaikum. Salam sejahtera. Good morning to all. Yang amat arif, demi manfaat para hadirin yang datang dari negara-negara asing pada pagi ini, saya dengan rendah diri memohon izin Yang amat arif untuk meneruskan ucapan saya dalam bahasa Inggeris. Much obliged, my lady. I'm honored and privileged to address your ladyship and this esteemed assembly on the occasion of the opening of the legal year 2025. It is my distinct pleasure to do so on behalf of the Malaysian Bar, the Advocates Association of Sarawak, and the Sabah Law Society. My esteemed colleagues, Gurveer Singh Sandhu and Muhammad Nazim Madwarin are in attendance, serving as presidents of the Advocates Association of Sarawak and the Sabah Law Society respectively. We take this opportunity to congratulate Yang Amat Arif, Datuk Sri Hasnah, Datuk Muhammad Hashim for her ladyship appointment as the Chief Judge of Malaya. Yang Amat Arif, Datuk Hanifah binti Fariqullah, Yang Amat Arif, Datuk Wazir Alam bin Maidimera, and Yang Amat Arif, Tan Sri Ahmad Tararuddin Muhammad Saleh for their elevation to the Federal Court. The 8 judges for their elevation to the Court of Appeal, the 19 judges for their elevation and appointment to the High Court, the 4 judicial commissioners for their appointment, Datuk Muhammad Dusuki Mokhtar for his appointment as the Attorney General, and former Attorney General Tan Sri Idus Harun, retired Federal Court Judge, Tan Sri Datuk Zainul Ali, former Sarawak Attorney General, Datuk Sri Talat Mahmud Abdul Rashid, and University Technology Mara Legal Advisor, Associate Professor Dr. Hartini Saripan for their appointment to the Judicial Appointments Commission, JAC. These appointments come at a pivotal moment, reaffirming the importance of transparent and merit-based process in selecting leaders for key legal and judicial institutions. The continued strengthening of judicial independence, accountability, and effectiveness is not only foundational to upholding the rule of law and ensuring public confidence in the Malaysian judicial system, must also serve as a cornerstone for fostering trust and stability within the broader framework of governance. Such trust resonates beyond our borders, reinforcing Malaysia's standing in the international community and creating an environment conducive to long-term growth, innovation, and collaboration where future opportunities, legal and otherwise, may thrive. Additionally, my lady, in attendance this morning, we have our esteemed colleagues from foreign bars, law societies, and law associations. We have with us the President of Law Asia, International Association of Lawyers, UIA, Law Society of Singapore, the Law Society of Hong Kong, Hong Kong Bar Association, Taiwan Bar Association of India, Integrated Bar of Philippines, IBP, and Law Society of Brunei Darussalam. We express our utmost appreciation for your presence this morning. My lady, I begin with a truth that resonates deeply within our justice system, a truth encapsulated in the Malay proverb, sedangkan lidah lagi tergigit, which reminds us that even the closest relationship can experience discord. Conflict, it seems, is an inevitable companion in the pursuit of justice. We are no strangers to these challenges. They emerge in the courtroom, within our institutions, and, at times, in society's very perception of justice. This reality is not failure, but a reflection of the complexity of human interactions and diverse interests we are called to balance. The phrase, fighting for justice, resonates deeply with us all. Advocacy by its very nature is adversarial. It is through the robust contestation of arguments, evidence, and interpretation of the law that we seek the truth to ensure fairness. Yet, this adversarial process, while necessary, must be tempered. Advocacy must be marked not by acrimony, but integrity, professionalism, and unwavering focus on the higher purpose, the administration of justice for the greater good. This is where we see the contrast with mediation. Mediation is not a replacement for litigation. Rather, it complements our adversarial system by offering a platform grounded in empathy and reasoned dialogue. It reminds us that justice can also be achieved through understanding, collaboration, and resolution that respects the interests of all parties. Litigation and mediation serve distinct purposes, but they share common principles: fairness, dignity, and resolution. As custodians of justice, we must ask ourselves a crucial question. Are we building a system that promotes solutions with compassion and fairness, or one that exacerbates division? It is incumbent upon us to resolve disputes in a manner not only upholds the rule of law, but also preserves relationships, restores trust, and strengthens society. For in doing so, we fortify the people's confidence in our legal system and uphold justice in its truest sense. As we reflect on the pursuit of justice, it is imperative to underscore the paramount importance of judicial independence. The adage, justice must not only be done, but must also be seen to be done, serve as a timeless reminder that the judiciary must remain beyond reproach, embodying integrity and impartiality. Society's trust hinges on this perception, and it is our collective duty to ensure that the judiciary remains, as the saying goes, whiter than white. To achieve the ideal of whiter than white, we must confront the overlap between politics, the judiciary, and the rule of law. Public trust in our institution is fragile, and restoring it requires transparency and decisive reforms. Our critical step is the proposed separation of the Attorney General and the Public Prosecutor, a reform I had privilege of contributing during its consultation phase. This change is crucial in ensuring impartiality and rebuilding confidence in our legal system. As Lord Denning wisely remarked, law does not stand still. It moves continually. Once this is recognized, then the task of a judge is put on a high plane. He must consciously mold the law so as to serve the needs of the time. He must not be a mere mechanic, a mere working mason, laying brick on brick without thought to the overall design. He must be an architect, thinking of the structure as a whole building for society. A system of law which is strong, durable, and just is on his work that the civilized society depends. This is particularly relevant to us in Malaysia and across the Commonwealth. Our legal frameworks are inherited, but their interpretation and application must reflect the realities of our society. Judges bear the solemn duty of interpreting laws with wisdom, discernment, and fairness, ensuring that justice is served in both spirit and form. Let us reaffirm that the independence of judiciary is not negotiable. It is the bedrock upon which justice stands. On the points of reform, my lady, just as slavery is now viewed with shock and incomprehension, it's not difficult to imagine that in 100 years, society may look at the current prison system with a similar sense of disbelief. Confining human beings in isolated spaces, often under conditions that fail to rehabilitate or respect basic dignity, may come to be seen as archaic and ineffective. Given these challenges, alternatives to incarceration, such as restorative justice, community service programs, and rehabilitation-focused initiatives present promising options. These models emphasize healing for victims, accountability for offenders, and crucially, the possibility of redemption. Countries like Norway, which prioritize humane treatment and rehabilitation, report significantly lower recidivism rates, underscoring the efficacy of these approaches. For Malaysia, the time is right to consider serious reforms. A shift towards restorative justice could address underlying issues that lead to crime, such as poverty, lack of education, and mental health struggles. Legislative changes to promote alternative sentencing, investment in community-based programs, and focus on rehabilitation over punishment could pave the way for more compassionate and effective justice system. The question before us is this: do we wish to perpetuate a system that confines individuals to their worst mistakes, or do we seek one that recognizes their potential for redemption? Reforming our prison system is not merely a matter of policy, it's a matter of principle. A just society does not merely punish, it seeks to rehabilitate and restore. As we move in 2025, the Malaysian Bar remains resolute to our duty as enshrined in the Legal Profession Act 1976. We seek to not only to serve the profession, but to champion the cause of justice and advocate for necessary legal reforms. My lady, allow me to share an observation, one that reflects the evolution of society and norms. First, we were warned to not get into a car with strangers. Later, we were warned to not engage with strangers on the internet. But today, we summon strangers via e-hailing apps and get into a car with them. This is illustrative of an evolving society. As guardians of justice, let us rise to the challenge of ensuring that our legal system meets the demand of an evolving society while remaining true to its foundational principles of fairness and equity. A final point, my lady. Though Malaysian Bar has often been accused of being political, as some claim our statements lack neutrality, alleging we either oppose or support the government of the day. The reality, however, is far more nuanced. We are over 24,000 strong, with expertise in legal matters that we practice daily. Logic dictates that we are uniquely positioned to assist in shaping and advising on laws that serve society. Yet we see there are some efforts by certain parties to marginalize us, either by dismissing our input or consulting us without genuine regard for our views. Even worse, some significant laws are being passed without any consultation with us. This disregard undermines our collective expertise. Let it be clear that opinions and the contributions we provide are always aimed to ensuring that fairness prevails and that the rule of law is upheld. If this trend continues, these issues will inevitably find resolution in courts. There is another reason why independence of judiciary is paramount, ensuring that society is not led astray by short-sighted objectives, if any, but instead guided by principles of justice and the rule of law. The Bar remains steadfast in its mission, not for politics, but for people. Our role is not just to interpret law, but to advocate for laws that are just, inclusive, and reflective of societal needs. Ignoring our voice is a disservice to the very people whom the laws are meant to protect. To end with a short poem. In halls where law and truth converge, justice stands, it calls and urges, not to punish, but to restore a chance for grace and something more. The scales may tip, the times may change, yet principles must not estrange. For as we rise to meet the day, justice must lead, come what may. On behalf of the Malaysian Bar, the Advocates Association of Sarawak, and the Sabah Law Society, I wish members of the Judiciary, the Attorney General's Chamber, and the members of the Bar a healthy, fruitful, successful, and peaceful year ahead. Assalamu alaikum. Thank you very much.
Thank you. I now invite the Honorable Datuk Muhammad Duzuki bin Mokhtar, the Attorney General of Malaysia, to deliver his speech.
My lady, I know a lot of people are expecting my maiden speech. I try my best and it won't be long. May it please your honors, Yang Ma'arif, Tun Tengku Maimun, Tuan Mat, the Chief Justice of Malaysia, Yang Ma'arif Tan Sri Dato' Amar, Abang Iskandar bin Abang Hashim, the President of the Court of Appeal, Yang Ma'arif Datuk Sri Hasnah binti Datuk Muhammad Hashim, Chief Judge of Malaya. Yang Ma'arif Tan Sri Abdul Rahman bin Sibli, Chief Judge of Sabah and Sarawak, Judges of the Superior Courts and Judicial Commissioners, Honorable State Attorney General of Sabah, Honorable State Attorney General of Sarawak, President of the Malaysian Bar, President of the Sabah Law Society, President of the Advocates Association of Sarawak, fellow officers of the Judicial and Legal Service, distinguished guests, members of the legal fraternity, ladies and gentlemen. Assalamualaikum warahmatullahi ta'ala wabarakatuh. A very good morning, warm greetings and salam Malaysia Madani. Honorable Chief Justice, esteemed members of the Judiciary, distinguished colleagues in the legal profession, respected guests and ladies and gentlemen, may I begin by recording my most profound and utmost appreciation to the Malaysian Judiciary, particularly the Right Honourable Chief Justice of Malaysia, for the privilege and honour to address the esteemed gathering of the legal fraternity on this August and celebrated occasion of the opening of the legal year 2025. On this solemn occasion, I would like to express my special gratitude to Yang Berbahagia Tan Sri Idrus bin Harum, the former Attorney General, from 6 March 2020 until 6 September 2023, and my predecessor, Federal Court Judge Yang Arif Tan Sri Ahmad Terudin bin Muhammad Saleh, who held the Attorney General Chambers for the period of 1 year before I took office on 12 November 2024, and all our predecessors for their tireless work in ensuring our legal system remains a beacon of fairness and stability. It's not too late to congratulate Yang Arif Tan Sri Ahmad Terudin for the appointment and your dedication, Tan Sri, in ensuring the success of AGC during your tenure as the Attorney General is much appreciated. One day I hope I will appear before you in court, my Lord. Yang Arif, ladies and gentlemen, it has been almost 2 years since the vision of civilized, skilled and inclusive society style in the outfit of Malaysia Madani was introduced by Prime Minister Yang Berhormat Datuk Sri Anwar Ibrahim. As the rakyat who also wears the hat of a public officer, Malaysia Madani is not just a brand imprinted on our official letters or a lip service we pay in our opening speech remark. Instead, it is a common goal that all citizens, especially us in public service, must aspire to achieve and assist. Thus, as the principal legal advisor to the government, AGC plays a vital role in ensuring that all government initiatives are implemented in accordance with the law. As we usher in the new year, I wish to mention some of the AGC's notable contributions in bringing the country to better heights. First, as the legal advisors and parliamentary drafters for the government, AGC officers collaborated with the Ministry of Home Affairs to ensure that the Constitution Amendment Bill 2024 saw the day. The historic amendments to the Federal Constitution, among others, accorded equal rights to citizenship by operation of law for children born outside the Federation, whose mothers were Malaysian citizens at the time of the children's birth. Secondly, pursuant to the coming into force of the revision of sentence of death and imprisonment for natural life, temporary jurisdiction of the Federal Court Act 2023, on 12 September 2023, AGC officers had worked relentlessly to handle application for revision of death sentences and imprisonment for natural life. The team has successfully disposed all of the 1,056 applications fixed in the Federal Court. The credit should also be given to me, my lady, because I also involved in the process. I appeared many times before your ladyship in few occasions, my lady. Thirdly, my office has played a major role in asserting Malaysia's position at the public hearings concerning the International Court of Justice advisory opinion on the legal consequences of Israel's policies and practices in the occupied Palestinian territory, including East Jerusalem at the Peace Palace in The Hague, Netherlands. Further, during the 62nd annual meeting of the Asian African Legal Consultative Organization, or ALCO, held in Bangkok, Thailand, Malaysia addressed several key topics, including its firm stance against Israel's violation of international law in the occupied Palestinian territory. Fourthly, in March 2024, the World Trade Organization, or WTO, panels had decided in favor of Malaysia in the case of government of Malaysia against European Union and several EU member states concerning palm oil and oil palm crop-based biofuels. WTO panels decided that there are elements of EU regulation that have violated the principle of non-discrimination under the WTO rules, and the EU should comply with the panel's decision by modifying its rules accordingly. AGC officers were part of the successful Malaysian team, Bravo AGC team. And fifthly, aiming to reform the civil service, AGC was instrumental in the historic formulation and execution of the new public service circular called Sistem Saraan Perkhidmatan Awam, or SSPA, to implement the new remuneration scheme for the public service. Among the improvements brought about by this new service scheme are new salary packages and retirement benefits, including replacing pensionable with annuity schemes for new recruits. The construct of this new scheme reaches every member of the federal public service, and all the states, statutory authorities and local authorities may adopt the SSPA. Yang Ma'arif, ladies and gentlemen, the role of a drafting officer of AGC extends far beyond just perfecting the language of a bill. As civil servants, it is our duty to draft the most acceptable bills, given the interplay of stakeholders' aspiration, interests, and standpoints. The year 2024 is no different in that, as AGC has held steadfast in realizing the government's legislative efforts and reform agendas in various fields, including finance, business, security, health, education, and administration of justice. The following are some of the key highlights, Melody. AGC played a key role in the rapid developments of the Cyber Security Act 2024, along with its 4 accompanying regulations. The collaboration for AGC team and the National Cyber Security Agency, or NACSA, has ensured that Malaysia is equipped with a cybersecurity framework to confront emerging cyber threats effectively, as it creates a secure digital environment essential for businesses seeking to protect their operation and sensitive data. Strong cybersecurity measures enhance trust and confidence in Malaysia's digital infrastructure, making the country an appealing destination for tech companies and innovation. The enactment of the Control of Smoking Products for Public Act 2024, or Act 852, represent a significant effort to address the growing concern of children and teenagers being exposed to electronic cigarettes and vaping. The Act had undergone scrutiny by the Special Select Committee twice and generated widespread debate across the nation. Many people doesn't like this Act, Melody. Additionally, necessary amendments were made to the Food Act 1983 to remove all provisions related to tobacco products, which are now entirely governed by Act 852. The intention to create a centralized agency to manage and protect Malaysia's borders has finally come to fruition with the enactment of the Malaysian Border Control and Protection Agency, Act 2024. The Act aimed to overcome the massive bureaucratic and operational issues of having various enforcement agencies operate at entry points, each with different procedures, which complicates the movement of people entering and exiting Malaysia and contributes to congestion. The Evidence of Child Witness Act 2007 was also amended to empower the court to secure conviction based solely on the testimony of a child witness, even in the absence of corroboration, and provides for the competency of child witnesses, procedures for their testimony, and inquiries to assess a child's understanding of the oath. Consequential amendments were made to Evidence Act, the Sexual Offences Against Children Act, the Oath and Information Act, and the Security Offences Special Measures Act, as well as the Armed Forces Act. to streamline the procedural and substantive aspects of evidence from child witnesses. Next, the amendment to the Audit Act 1957 empowers the Auditor General to examine, inquire into and audit the accounts of any entity, including companies registered under the Companies Act 2016, that receive a financial guarantee from the Federation or the states. In line with the principle of follow the public money audit, the amendment emphasizes transparency, accountability, and the proper management of public funds. The enactment of the Penal Code Amendment Act 2024, which addresses offences related to payment instruments and accounts at financial institutions, was a response to the alarming rise of online financial fraud in the country. As an effort to improve access to justice, foster a more equitable arbitration process in Malaysia, and enhance Malaysia's standing amongst the global international arbitration community, the Arbitration Act 2005 was amended to introduce, amongst others, the comprehensive framework for third-party funding, ensuring transparency and integrity through statutory disclosure requirement and code of practice. My lady, apart from the noteworthy legislative move, which have been passed by the Parliament, another 42 bills have been drafted and tabled, and 708 subsidiary legislation have been published in the Gazette in 2024. Just, we can imagine the immense work that we are enduring, my lady. Yang Arif, ladies and gentlemen, in 2024, AGC has also remained committed to ensuring that the present legislation meets the current needs of societies and is in line with modern day developments. Hence, realizing the critical importance of the Court of Judicature Act 1964, Act 91, to the legal fraternity and the public at large, AGC and the Chief Registrar Office of the Federal Court of Malaysia collaborated in reprinting Act 91 to ensure that all relevant amendments are incorporated into the new reprinted Act. AGC has been collaborating with the Legal Affairs Division of the Prime Minister's Department to implement two law reform projects proposed by the government in 2034, namely the Public Advocacy Bill to replace the Legal Aid 1971 and the amendment of laws relating trust, renting to trust in Malaysia. Yang Arif, ladies and gentlemen, aligned with the government Digital Transformation Directive, AGC has developed an online system known as Module Daftar Kertas Siasatan, e-Daftar, and Module e-Representasi, or e-Rep. Apart from being environmentally friendly due to the paperless approach, digital case management systems allow for efficient tracking of cases from the initial investigation to the final verdict. These systems are equipped with alert features which will notify us through email should the time allocated for specific action be about to lapse or expire. These systems can reduce the time and resources required to manage large volumes of criminal cases, allowing prosecutors to focus on the substantive aspects of their work. e-Daftar is a system which enables enforcement agencies to register their criminal investigation papers online. As of early December 2024, this system has recorded more than 450,000 investigation papers and is currently being used in 10 states, 161 agencies, and by 391 deputy public prosecutors. The system will be expanded to the whole country before the year end. I hope Bar Council we will feel happy when this system is implemented. The e-Rep, we replace the manual process for handling representation submitted by lawyers. Lawyers will be automatically notified through emails, and the status of representation can be checked online. My lady, besides that, AGC has also embarked on the case decision reporting, or LKKI AGC system. The LKKI AGC system, which can be accessed from any device or location ensures that reports of the lower court decision are sent to the appellate and trial division for further instruction to the prosecutors regarding the next course of action at the appellate level and will be extended to all relevant agencies. Yang Arif, ladies and gentlemen, in 2024, the AGC continued to navigate our country's complex legal terrain while relentlessly defending the government's interest in a series of high-stakes cases, from constitutional challenges that tested the limits of governments to landmark public interest litigation, the government's unyielding dedication to the greater good of the society served as a beacon to AGC's pursuit of integrity and fairness in each and every case we handle. Some notable highlights from the past year include the case of A against Mahkamah Rayuan Syariah Wilayah Persekutuan, and also in the case of Chong Tong Sing and another against Menteri Dalam Negeri and another. Both cases were decided at the federal court level, Melody. The AGC has stayed true and will continue to honor our commitment to ensuring that public interest litigation are resolved expeditiously. This includes exploring the possibility of re-evaluating the allocation of officers to handle civil matters to reflect on the increasing workloads and complexity of matters being handled. Our commitment also extends to working hand in hand with our clients' departments to ensure that public officers are equipped with knowledge of the prevailing laws by guiding ongoing cases, as well as giving lectures in courses and knowledge sharing sessions. These efforts are aimed at ensuring that our client departments are kept abreast of the current legal trends, as it will help them to take prompt actions to minimize any legal risks or setbacks. Additionally, in striving to modernize our daily operation with digital advancement, the AGC, through our civil divisions, had also looked into ways to expedite and facilitate the consent of the Attorney General under Subsection 9(1) of the Government Proceedings Act, or Act 359, to institute a suit in relation to public, religious, social, or charitable trust in Peninsular Malaysia. Accordingly, we are pleased to share that we have successfully implemented online application via AGC's e-service portal for all requests related to the Attorney General's consent under Section 9 of the Act 359, starting from 1st August 2024. Yang Arif, ladies and gentlemen, the role of AGC is not confined to the domestic legal context, but extended beyond our borders, particularly in the realm of international law and foreign relations. It is noteworthy to highlight AGC's contribution in the following events. In August 2024, after over 3 years of negotiation, Malaysia concluded its participation in the drafting of United Nations Convention Against Cybercrime, led by National Cyber Security Agency, or NACSA, and supported by AGC. The final session of the ad hoc committee took place in New York from 29 July to 9 August 2024. In 2024, Malaysia also concluded 2 significant instruments under the leadership of the Ministry of Home Affairs. The MOU with the United States, signed on 2nd August 2024, strengthens cooperation in combating terrorist crime, while the treaty with Iran, signed on 24 July 2024, provides a legal framework for the international transfer of prisoners. Yang Arif, ladies and gentlemen, the year 2024 has seen the initiation of many reforms. AGC was part of these watershed moments and played the key roles in the establishment of Chief Children Commissioner and Children Commissioners by law under the auspices of the Human Rights Commission of Malaysia, to specifically deal with human rights matters relating to children. Further, as the legal advisor to the government, AGC has been involved in negotiation of many high-impact projects implemented both through the public-private partnership, PPP, and conventional methods. To date, AGC has been involved in many projects where we have played a pivotal role. There are too many to name, and listing only a few would do injustice to the sacrifices of our officers who have poured their heart and soul into protecting the interests of the government and the public. Yang Arif, ladies and gentlemen, AGC also places great emphasis on the importance of lifelong learning. To this end, we have actively sought and collaborated with the Public Service Department or JPA, public universities, and government-linked companies to ensure that our legal officers can pursue their postgraduate opportunities locally and internationally. Ya Ma'arif, ladies and gentlemen, in 2024 also, AGC celebrated several warm memories and milestones reflecting its rich history and ongoing commitment to legal service. Among the highlights were Persidangan Pegawai Undang-Undang 2024, which was the idea of Yang Arif Tan Sri Ahmad Terudin, which has brought together 1,500 AGC legal officers from across the country, was successfully held in August 2024. The inaugural AGC Coffee Book Table entitled Journey Through Time from Kuala Lumpur to Putrajaya was also launched at the conference, which showcased AGC's journey, its milestone, and its contribution to the nation's legal development. We have also made a strategic move to send legal attaches to key international institutions, namely the permanent mission of Malaysia to the United Nations, New York, and the Embassy of Malaysia in The Hague, Netherlands. Efforts are also underway to place our officers in the office of the permanent rep of Malaysia to the WTO in Geneva, Switzerland. The AGC has taken the initiative to engage with the community by holding the Kampung Angkat Madani program at Kampung Jelit 8, Mungkin Bujang, Kuala Muda, Kedah. The program exhibits the serious commitment of the Madani government to ensuring all walks of the rakyat would benefit from government development efforts. To this end, AGC has overseen the construction of crucial infrastructures, including a local bridge, jetty, and football field. The program is still ongoing, and various community welfare and education programs have been carried out. Ya Ma'arif, ladies and gentlemen, in the coming year, we look forward to facing new challenges and seize new opportunities for growth and progress. We will continue to work towards serving the nation by enhancing access to justice for all, ensuring that the law remains accessible, transparent, and fair. Ya Ma'arif, I'm now entering into the final stage of my speech, Ya Ma'arif. I would like to quote a verse from the Surah Al-Ma'idah, verse 8 of the Quran, of the Holy Quran. The translation reads as follows: O believers, stand firm for Allah and bear true testimony. Do not let the hatred of a people lead you to injustice. Be just, that is closer to righteousness, and be mindful of Allah. Surely Allah is all aware of what you do. With that in mind, allow me to conclude by emphasizing that the cooperation of the AGC, the Judiciary, and the Bar is vital. Please allow me to recite two passages of pantun or Malay poem to illustrate this message that I just mentioned, my lady. Indah jambangan bersilang ranting, bunganya sarat cantik digantung. Andai ringan sama dibanting, kalau berat sama diusung. Pergi ke pasar membawa bakul untuk diisi baju dan kain. Ringan dan berat sama dipikul, tanda muafakat erat terjalin. For those who do not understand Bahasa Malaysia, please come and see me after this. As we embark on another year, I would like to take, it's all about cooperation between agencies. As we embark on another year, I would like to take this opportunity to thank all, and let us do so with a renewed resolve to advance justice, promote the rule of law, and contribute to a just society for all. Let me end my speech with Nelson Mandela's famous call: let there be justice for all, let there be peace for all. Thank you, and I wish you all a successful and fulfilling year. Much obliged, my lady, my lords.
Thank you. Brother and sister judges and judicial commissioners, Your Excellencies, distinguished guests, ladies and gentlemen. Assalamu alaikum warahmatullahi wabarakatuh, and a very good morning. I would like to begin by thanking each and every one of you for gracing us with your presence on this August occasion of the opening of the legal year 2025. With the onset of the new year and new beginnings, I would like to congratulate each and every judge who was appointed in the last year. At the same time, I would like to wish all judges who retired in the past year a very happy retirement. While a big congratulations go out to everyone who has been appointed as judges, especially to the Apex Court, there is little or no reason for anyone to begrudge you. As a judge, you have taken the oath of office to protect, preserve, and defend the Constitution of Malaysia. It is the most formidable and painful of oaths. By taking up judgeship, let me remind you of its implications. You have agreed to live a life of solitude, and you have relinquished loyalty to any institution apart from the judiciary and the federal constitution. You have agreed to become the perfect citizen who accommodates no advice and adheres to no one's instruction apart from the dictates and mandates of the Constitution and the law. You know politics, carry out your duty as a voter, but take no part in it in any way, shape, or form. You are tasked to do justice by the law, but at the same time, you have become dispassionate to all manner of sufferings, plights, and pain, as these are only secondary to the law. A case, no matter its size, no matter the litigant, no matter the external circumstances, no matter the price, no matter the interest, and certainly no matter your personal view, is ancillary to what the law and facts demand. You, as a person, may feel strongly averse to the death penalty, but when the facts of the case require it, you must pass the sentence. You may not like the people or ethics behind a dubious cooperation, but when the facts support it, pass judgment in their favor. As a mother, you may feel the pain and suffering of another mother who stands to lose her children, but where the facts require it, you must remove that child from her. Being a judge is a tireless, thankless, and a challenging profession. No matter which way you decide, there will always be at least one disgruntled party. You are constantly under watch and scrutiny, not only from the litigants that seek justice before you, but from the entire public that remunerates you and trusts that you will set aside your own persona, your own ideals, and your own personal biases in favor of something much larger than you, the Constitution and the law. For those of you who think that being a judge is effortless or a simple job, let me enlighten you of its reality. In a civil or commercial setting, you are faced with hundreds of cases, with all of them disclosing various complex issues, all of which you must make every effort to understand. You face complex shareholder disputes, oppression and winding up petitions, which concern the interests of not only the petitioner, but of creditors, secured and unsecured, such as employees, and in some cases, investors that include members of the public. You may have to consider prolix defamation pleadings, injunction applications, or even technical intellectual property disputes. In each of these cases, documents may run into thousands of pages. In a criminal trial, you are faced with mostly charges that involve the death penalty. Not to mention, the High Court has to deal with trials and appeals almost on a daily basis, containing harrowing facts and images involving gruesome murders, sexual abuse, and rape cases, especially those involving children, and having to unravel the complex web of anti-money laundering and other corruption cases. Family court judges deal with acrimonious divorce petitions, sometimes leaving the judge almost drained with having to confront the distressing emotions involved, having to interview small children, and sometimes needing to ask them whether they wish to stay with their father or mother on an almost daily basis is not something someone with a conscience can manage mentally for too long. And in some cases, you will find that neither the father nor the mother is fit to be a parent, and yet you have to choose for the child to live with either the devil or the deep blue sea. But decide you must. These examples can go on ad infinitum. Those who have been lawyers would have had the option of finishing a case and getting paid for it. However, as a judge, a case you dealt with once or twice as a lawyer might become routine. You are no longer acting for your clients. As a judge, you now have to deal with the issues from a different perspective. You are resolving the issues objectively with your experience and inside knowledge as a former advocate. In a criminal case, you are no longer defense counsel. You must be able to remove yourself from such a notion and convict the very kinds of people you once worked to defend. If you had been in the public service, you would have adhered to the maxim of serving the nation, not the government. As a judge, you will constantly find the government suing or being sued, and you must continuously remind yourself that serving the interests of your nation is not the same as allowing the government a win in every case. I speak today as the outgoing Chief Justice of Malaysia. My colleagues and I have, in at least one part of our judicial careers, faced these challenges. Additionally, as Chief Justice, I have carried the burden, image, and overall responsibilities of the judiciary for almost 6 years. And what a task it has been, one that I do not envy the next person who should carry it. As Chief Justice, I have been criticized, vilified, been labeled an Islamic or an enemy of Islam. My husband, unfairly so, has been used against me in some applications to not only have me recused, but more generally, to embarrass me and my colleagues. None of them have or ever will pass the test of my conscience, and praise be to Allah, I have not once lost sleep over these comments. When I was appointed the first female Chief Justice of Malaysia, someone asked me, what would you do if the executive or any other influential party demands that you decide a case in a certain way? What would you do if history were to repeat itself? You are faced with requests to appoint certain persons as judges or make decisions that you know to be wrong in law, but right for the party with a vested interest. Before I answer the question, let me stress this. A judge, whether male or female, must always decide justly, fairly, and objectively. I am happy to share with you today what my answer to that long question was and still remains till today. It is this. I am here to do my job. I never coveted for it, but by the grace of Allah subhanahu wa ta'ala, I was entrusted to lead the judiciary. It is an extremely intimidating position to hold, but upon accepting the appointment, I am fully committed to doing it properly. I will not bend or bow to any person, no matter how high and mighty, to do what he or she demands of me. My only master is Allah subhanahu wa ta'ala. I have utmost faith in my religion, which holds me accountable only to Allah on Judgment Day. I always intend on fulfilling my oath of office, especially in ensuring the Constitution reigns supreme, and I am guided by no other considerations than the law and the facts of any case within the bounds of judicially established principles. In the soon-to-be 6 years within which I have served as Chief Justice, I have held firmly to the belief that what needs to be improved shall be improved, and what does not need to change shall remain. I do not believe that each time a person takes office, they have to override or cancel past policies that have proved useful for the sake of doing so. In this regard, I have retained whatever policies that were left behind at the time I took over that enhanced the judicial institution. As you recall, a lot has happened in the past 6 years alone than the decade before it combined. Only a year into my tenure in 2020, we were hit with the COVID-19 pandemic. Everything was put on hold and everyone was told to stay at home, but we all knew that justice cannot come to a standstill. We embarked upon digitalization and judicial modernization as early as 2009 under the leadership of the then Chief Justice Tun Zaki bin Tun Azmi. But in just the 1 year between 2020 and 2021, with the help of all the right parties, including Parliament, the Bar, and the AGC, the Malaysian Judiciary did more for the cause of technology than it could have done in the 10 years between 2009 and 2019. Our country was also faced with constitutional issues, beginning with the then Prime Minister's resignation in 2020. What then followed was a series of constitutional suits concerning, among other things, a declaration of emergency in the face of the pandemic, and overall, everyone witnessing the Constitution being tested to its limits. Generally, it has been an eventful almost 6 years. I think it is natural for anyone who has been through such an eventful period to feel wistful at the prospects of retirement. However, I, more than feeling sad, instead feel an overarching sense of relief. I am looking forward to retirement as I sincerely believe that I will get to leave the judiciary in a better place from when my colleagues and I led it, with a chance to spend more time with my grandchildren and to deepen my connection to my faith. As such, in this last holy speech of mine, I enjoin you to reflect upon two things that I believe to be of paramount importance moving forward. The first of these is the state of our constitutional law. The second has to do with judicial appointments. Arguably, the most important and foundational features of the Constitution are Articles 4 Clause 1, 5 Clause 1, and 8 Clause 1. The latter two jointly guarantee the right to life and personal liberty and equality before the law. The former ensures that the Constitution reigns supreme and that any law passed after Merdeka Day is void to the extent that it is inconsistent with the Constitution. We must remember that unlike many other written constitutions, ours was not won from Great Britain on the battlefield or drafted after a bloody internal revolution. It was negotiated by our leaders of the time. In the United Kingdom, they effectively only have one rule which forms their unwritten constitution, and that is Parliament is supreme. This means that Parliament, as the collective representative of the people, has the supreme power to make any law, even to the extent that it changes fundamental constitutional provisions in Great Britain. The Constitution and the law there is, in effect, whatever Parliament says it is. The same is not true here. Here, Parliament is not supreme. Here, Parliament itself is enacted by the Constitution, and its powers are demarcated between itself and the state legislatures. While these legislative powers are broad, they remain circumscribed and expressly enumerated in legislative entries to the 9th schedule of the Constitution. When I took office as the Chief Justice, 3 celebrated judgments had already been pronounced by the Federal Court. These are, as you know, firstly, Commemorative, secondly, Indira Gandhi, and finally, Al-Manudu, the trilogy of cases. These cases collectively held what I believe is right in law, which is that the supremacy of the Constitution is exercised by the superior courts as the only collective body with the inherent power to do justice by interpreting the Constitution. It was essentially held in the trilogy of cases that judicial power cannot be curtailed in the manner, or rather in the way the amended Article 121 Clause 1 suggests. What these cases cemented is what is now known as the doctrine of constitutional supremacy, in that any law passed by Parliament, even law seeking to amend the Constitution, can be struck down as being void. In the years that followed the trilogy of cases, we saw numerous challenges to ouster clauses. In opposing the challenges, the argument advanced was that the constitutional amendments made in 1988 effectively whittled down judicial power in Article 121 Clause 1, such that the courts were required to abide by and their powers be circumscribed by federal law. Sometime into my tenure, the Federal Court finally held in two cases, i.e. Nivesh Nair and Dinesh Tanapil, that Article 121 Clause 1 cannot be read in the way it was once read to make the courts subservient to Parliament. These decisions were not based on a new invention. They were decided purely upon the application or expansion of principles established in the trilogy of cases. As such, the constitutional decisions in the past 6 years have only permanently endorsed the notion that there are basic features of the Constitution that cannot be altered or taken away, even by way of a constitutional amendment. And even if such constitutional amendment was made, it can be struck down under Article 4, Clause 1. Since then, many have come to misunderstand these decisions. Some misinformed parties take the position that these cases mean that Parliament cannot ever amend the Constitution. I shall not repeat the explanations given in recent judgments that clearly explain why this position is wrong, but I will say this. The Constitution is not just a mere collection of words. It is a blueprint as much as it is a living reminder of our history. Due to the nature of its founding, including the fact that the Constitution renders Parliament subordinate to it, the Constitution is greater than the sum of its words. Upon an examination of the historical documents and the circumstances of the formation of Malaya and later Malaysia, it is surmised that some fundamental features of the Constitution include Islam as the religion of the Federation, the supremacy of the Constitution, the national language of the Federation, the special position of the Malays and natives of any of the states of Sabah and Sarawak, a democratic constitutional monarchy with 3 branches of government being the executive, the legislatures, federal and state, and an entirely independent judiciary, and the written guarantee of fundamental rights as well as their protection. These categories are not closed. To whittle away any of these features would be to destroy the essence of the Constitution itself. It does not mean Parliament cannot amend the Constitution. The procedure for this is clear. What it does mean is that Parliament, being subordinate to the Constitution, cannot, even with the requisite majorities and consents, directly or indirectly eradicate these features at the risk of destroying the Constitution and Malaysia itself. It means that Parliament cannot at any time use the constitutional procedure for amendment by, for example, eliminating the special position of the Malays, abolish the monarchy, or even, for that matter, remove Islam as the religion of the Federation. The existence of this doctrine of constitutional supremacy that upholds not just the words and explicit provisions of the Constitution, but protects its spirit, implied principles, and design is an indelible principle of our rule of law. This is where the ouster clause cases come into sharp focus. Who is to ensure that the Constitution is preserved and its supremacy upheld? It must be the superior courts. Ouster clauses were challenged on the ground that they insulated the executive from any form of meaningful review by the courts. The argument in support of their constitutionality was premised on the ground that the courts were in effect bound to comply with the ouster clauses under the amended Article 121 Clause 1 as they are federal law. It is for this reason that the amendment to Article 121 Clause 1 was argued to be unconstitutional and that it ought to be struck down under the doctrine of constitutional supremacy, which was earlier known as the Basic Structure Doctrine. Recent decisions ultimately held that the amendment to Article 121 Clause 1 was not unconstitutional because, when read in its proper context, with Article 4 Clause 1, the amendment did not abridge judicial power. In this regard, while Article 4 Clause 1 rendered all laws in violation of the Constitution void to the extent of their inconsistency, in effect, such a declaration of supremacy would be meaningless if federal law, in the form of ouster clauses, could come in the way of any assessment on the validity of laws so passed or any executive actions taken in the name of those laws. The application of the doctrine of constitutional supremacy is not just confined and applicable to the judiciary through Article 121 Clause 1. Although litigation on this doctrine has mostly been in respect of Article 121 Clause 1, the application of the constitutional supremacy bears implications to constitutional features far deeper than that, such as to all aspects of our government, our governance, and our constitutional identity that collectively make Malaysia the country it is. In the last 6 years, litigation and judicial decisions have affirmatively determined that the doctrine of constitutional supremacy is here to stay. Litigation should only develop now to the extent of what those features include and whether they have been eroded in any way. Any future decision that denies the existence of the doctrine of constitutional supremacy or which seeks to re-establish now overruled cases that dismiss the doctrine would amount to a major regression in the development of our constitutional jurisprudence. Apart from the doctrine of constitutional supremacy, there have been other significant constitutional developments. For instance, the Federal Court decision in CCH has strengthened the plight of stateless children who were found to be abandoned at birth and whose mothers cannot be identified. This decision, I believe, has re-established the scope and extent of all the applicable constitutional provisions, as well as the principles that must apply to the most basic of rights, the right to citizenship. Still, in the realm of constitutional law, the last 6 years have also seen major litigation on the extent and scope of powers of the federal and state legislature. These decisions include the judgments of the Federal Court in PICC Putra, Sis Forum, Wong Shikai, and Nick Allen. As mentioned earlier, Parliament and the state legislatures are the creations of the Constitution, and their powers of legislation are circumscribed by the 9th schedule. Apart from what is contained in the concurrent list, the Constitution is more than clear that, absent certain circumstances that were inapplicable in those cases, Parliament or state legislature cannot make laws on matters that fall within the purview of the other. In all those decided cases, the simple and straightforward question was whether the state legislatures in those cases were empowered to make certain criminal laws. It was found, as has always been the case, that only Parliament can make criminal laws of a general nature to be applied to all citizens. The states in those cases justified those laws on the ground that they only made those laws in respect of Muslims in those states. Upon an analysis of the pith and substance of those laws, the Federal Court agreed in all those cases that the laws in question, not all in Nick Allen, were not only applicable to Muslims in principle, but pertained to general criminal laws. On this basis, and consonant with Article 4, Clause 1 of the Federal Constitution, the Federal Court did its duty by striking down those laws for being in excess of the powers of the state legislatures to make those laws, and which powers rightfully belong to Parliament. That is all it was. Yet, you would invariably have seen that some parties spun those decisions to appear as if the judiciary or some judges within it, including me, are anti-Islam. Some even question my faith as a Muslim. I woke up every day praying and hoping that the most beneficent and most merciful Allah subhanahu wa ta'ala accepts my ibadah and deeds. It is not for me to question the faith of others because, in the first place, I will never know until the day of reckoning whether Allah subhanahu wa ta'ala has accepted my own. And so, I will not bring myself to stoop down the level of these scurrilous attacks, and instead, my only response to them is this one rhetorical question. For those of you who have the time to question the faith of others, are you confident enough that Allah, as the sole judge, has accepted your own ibadah and deeds, such that you have now been ordained the standing to question mine and of others? I stand firmly by what it is I do as a judge and Chief Justice, and I will continue to believe in what is right. The spin doctors, naysayers, and critics can say what they will and turn something noble into a purported vilification of Islam. But in the end, I hold dearly to the dictates of Allah as per the Holy Quran. O you who believe, stand out firmly for justice as witnesses to Allah, even as against yourselves or your parents or your kin, and whether it be against rich or poor, for Allah can best protect both. Follow not the lusts of your hearts, lest you swerve, and if you distort justice or decline to do justice, verily Allah is well acquainted with all that you do. Chapter 4, verse 135. Apart from constitutional law, there have also been significant developments in the realm of civil law and criminal law. There are too many to state. I will say that at least in my court and with my colleagues, every personality, regardless of his or her status, has been accorded like treatment and has received judgment appropriately. This has been the case in spite of all and every attempt to stymie or stifle the cause of justice. I am not the only one who is soon to retire. Many of my esteemed colleagues will soon retire as well. We will leave you to judge whether the landmark cases that have been passed in all fields in the last 6 years have met the standards of justice. All we can do now is entrust all future generations of judges, lawyers, prosecutors, and federal counsel to further progress the development of the law in line with established principles. It is here that I wish to remind judges to remember their oaths of office and adhere strictly to the doctrine of stare decisis. The second and final aspect of my focus is the topic of judicial appointments. This topic is of paramount importance for the following reasons. Firstly, the very building blocks of the judicial institution are its judges. A judge must not only be qualified on paper, but must carry with him or her the right temperament, physical stamina, and the mental courage to deal with the high demands of the duties of their office. If the wrong persons are appointed, the very cause of justice stands to be averted. It is almost impossible to build a resolute and entirely independent institution if its lead actors are not poised to play the part required of them. Secondly, we cannot deny the blemish in our history. That was the 1988 judicial crisis. This one crisis itself tarnished the independence of the judiciary and paved the way for further incursions into the institution. In its aftermath, we also witnessed completely unsettling events that are known as the infamous Wikelingam tapes. Most heinously, revelations were made that certain persons were literally deciding on who should become judges specifically as a means of reward, as though appointments of judges can be used as bargaining chips. These events called for an independent judicial appointments process to ensure that tarnished candidates do not stand a chance of appointment. Prior to 2009, the judicial process was rather simplistic in the sense that it was only based on a few provisions of the Constitution. Without getting too technical, when it comes to the appointment of ordinary Superior Court judges, the Prime Minister tenders his advice to the Yang di-Pertuan Agong upon consulting the Chief Justice and after conferring with the Conference of Rulers. This process underwent a radical shift in 2009 with the introduction of the Judicial Appointments Commission Act 2009, which established the Judicial Appointments Commission, or it is most commonly referred to JAC. What I am about to share with you next are not my personal views, but actual discussions that took place in the Dewan Rakyat regarding the passing of the Judicial Appointments Commission Act 2009. The need for the Judicial Appointments Commission Act 2009 were grounded on many allegations and attacks against the government. Pertinently, many members of the opposition appeared to express the sentiment that the introduction of the bill to the Judicial Appointments Commission Act 2009 was merely a cover-up for all the past appointments that had been made. I invite each and every one of you to scrutinize the Hansard for 16 December 2008 and 17 December 2008. Most of all, I find relevant the views of the then recently appointed leader of the opposition and current Prime Minister of Malaysia, Datuk Sri Anwar bin Ibrahim, who expressed strong views on the Wikelingam incident. Datuk Sri Anwar Ibrahim concluded then that the Judicial Appointments Commission Act 2009, in his view, was not enough to restore the independence of the judiciary. He went on to observe that there is a perception that persons who had decided in favor of the government were promoted. Datuk Sri Anwar Ibrahim's observation then relates directly to the fundamental aspect of judicial independence, in that perception plays a big part in it. The public cannot be expected to have confidence in the judicial institution, no matter how hard its judges work, if the pervading public perception is that judges are appointed or elevated upon the favor of making decisions that by default support the government of certain business interests. When things like this happen, it is very similar to, if not worse than, the lessons in the children's parable of the boy who cried wolf. Cried wolf wantonly could backfire when no one believes you, when the wolf actually arrives to eat the sheep. Applying it to us, making the irredeemable mistake of rendering one decision colored with bias, or appointing one candidate that is only chosen as a favor, throws into question the integrity of the entire judiciary, and none of the decisions delivered after that will engender the public confidence and trust, even if that decision is absolutely correct on the facts and the law. It takes decades to instill a steady level of trust and confidence in the judiciary. Judges work hard with considerable commitment towards this end. And since 2016 until now, that goal has largely been realized. Malaysia has improved on all major rule of law and judicial independence indices. In 2023, Malaysia ranked 55th out of 142 countries worldwide in our rule of law ranking, being among the minority of countries whose rankings improved in that year, a significant 23-place improvement from 2016. It is important to acknowledge that these are not merely statistics or empty figures. They denote the reality of how the country is viewed for purposes of investment and are requisites for economic and social progress. The best evidence of this is the research of the 2024 Nobel Prize winners for economics, whose research can briefly be summarized as empirically demonstrating the importance of strong institutions, a key one being the judiciary in fostering long-term and sustainable economic growth. To maintain this reputation, it is imperative that judicial independence, which is central to the rule of law, be upheld and enhanced. From 1988, it is only now that we are on the road to recovery in terms of our perception of independence. Incidentally, 15 years ago, when the Judicial Appointments Commission Act 2009 was enforced, the then leader of the opposition made the comments that he did, as reflected in the Hansard on the appointment of judges and judicial independence. I am certain that now, as Prime Minister, Datuk Sri Anwar Ibrahim and his government will remain true to those comments by continuing to unreservedly remain committed to upholding the cause of judicial independence. In spite of the many criticisms leveled against the Judicial Appointments Commission Act 2009 in the debates prior to its passing, the Judicial Appointments Commission Act remains in force. The purpose of the Act, as was clarified by the then government when moving the bill, was not to change the constitutional mechanisms of appointment of judges, but to further streamline and enhance the selection of candidates for judicial appointments. Viewed in this way, the provisions of the Judicial Appointments Commission Act 2009 and the establishment of the JAC is seen as a measure to supplement and complement the constitutional provisions on the appointment of judges of the superior courts. The Judicial Appointments Commission Act 2009 statutorily prescribed selection criteria for potential candidates for judicial appointments. These criteria are evaluated by JAC members who, ex officio, comprise the Chief Justice, the President of the Court of Appeal, the Chief Judges of the two High Courts, and members appointed by the Prime Minister, namely one Federal Court judge and 4 eminent persons. Typically, these 4 eminent persons are appointed from among the academia or from the pool of retired judges. These 4 eminent persons cannot be members of the executive or other public service and are appointed by the Prime Minister after consulting the Bar Council of Malaysia, the Sabah Law Society, the Advocates Association of Sarawak, the Attorney General of the Federation, and the Attorney General of a State Legal Service. Aspiring candidates apply to the JAC for appointment as judicial commissioners. The JAC also reviews the performance of sitting Superior Court judges and recommends them for elevation or promotion. These decisions have always been made by a majority vote through a secret ballot if there is no consensus, and in all my time as a member of the JAC, I have not once interfered with the process. The candidate who gets recommended is therefore not the sole choice of the Chief Justice, but either the choice of the majority or the collective decision of the JAC. In my opinion, this is a big improvement from what we did not have before. Any person who interferes with, commits an offense and shall on conviction be liable to a fine not exceeding 100,000 ringgit, imprisonment for not more than 2 years, or to both. Candidates that are selected are forwarded to the Prime Minister to appoint in accordance with the provisions of the Constitution. The provisions of the Judicial Appointments Commission Act 2009 do, however, allow the Prime Minister to not accept the candidates recommended by the JAC for appointments. In such cases, the Prime Minister can request for 2 more names of candidates. The mechanism of the Judicial Appointments Commission Act 2009 is far from perfect. As we can see from the parliamentary debates, there are many issues raised against it. Even after its passing, many quarters, including the Bar Council, have recommended changes to strengthen the Act. Foremost concerns the fact that the Prime Minister still has too much power in the appointment of judges. I do not wish to address the recommendations at this point. I am highlighting this to simply bring it back to the attention of the parties present here for possible improvements in the near future. That said, what is clear from the constitutional provisions on the appointment of judges read with the supplementing procedure in the Judicial Appointments Commission Act 2009 is this: no person other than the JAC and the Prime Minister can recommend candidates for appointment to all posts in the superior courts. Any form of circumvention of these provisions could render those appointments either unconstitutional or in breach of written law. For this reason, no person, whether it be the President of the Malaysian Bar, any advocate or solicitor, any political party, the Attorney General, or any other person for that matter, has any business recommending names to the Prime Minister for appointment. For if this is done, not only has the judiciary been trampled upon, its independence has been transgressed and eroded, it is an attempt to interfere with the course of justice by influencing the operations of the judiciary. And any name so considered on such improper advice runs the risk of being challenged via judicial review as being either unconstitutional or in breach of the law. Any person so found to have done this also runs the risk of being charged with an offense. I have been an ardent and firm believer in the independence of the judiciary, including the appointment of its judges. Hence, I have steadfastly observed all the principles espoused in the Constitution and the Judicial Appointments Commission Act 2009. If anyone has any reason to believe that we have not done this, then I would remind you that as the law and procedures stand, the JAC, again, is only but one part of the appointments process, and you should perhaps point the finger elsewhere. As I near the end of my tenure, it is my sincere hope that those responsible for the appointment of judges remember their commitments to their oaths and duties under the Constitution and law and continue to hold true to past comments or commitments that they may have made regarding the fair, independent, and unadulterated appointment of judges. To conclude, I will no longer continue to lead this institution in the coming months. As I leave, I hope that the appointment of the next Chief Justice is fully compliant with all aspects of the law, bearing in mind the need to keep the judiciary independent in view of the unfortunate and blemishing events of history. The law, too, has developed in a positive manner where fundamental rights and liberties are given their utmost interpretation and enforced to their maximum potential. The role of an independent judiciary has been restored, and the public are confident in us. All of us who are serving as judges, practicing at the bar, or even serving in public service will one day slow down to the point where we cannot carry out our current duties, either due to law or by age. Let us retire gracefully and happily, knowing full well that we left the institution far better than when we found it. We should gladly sit from afar and beam proudly at its growth rather than viewing it with concern that the judicial institution will turn into nothing but a mere shell of its former glory. To all my colleagues, judicial officers, and support staff of the past and present on the bench, our success as an institution would have only remained as a mere wishful thought without all your dedication and support. For that, I am eternally grateful. I would also like to thank all members of the executive branch of the government, past and present, and Parliament, for working with the judiciary to realize all policies, especially so during the most challenging moments of our time during the pandemic. Just a little trivia. My tenure is the first time in the history of this country where a Chief Justice's service has coincided with 4 different prime ministers, all from 4 different political affiliations, in the order of Tun Mahathir Mohamad, Tan Sri Muhyiddin Yassin, Datuk Sri Ismail Sabri Yaakob, and presently, Datuk Sri Anwar Ibrahim. During this time, judicial panels led by me have made what we firmly believe to be correct decisions on the law and facts, regardless of the heated political overtones and undertones that cloth some of those cases. This alone should dispel any baseless notion that I have ever been partial to any political prime minister or any political party. Ultimately, all my thanks and gratitude are owed to Allah subhanahu wa ta'ala, for as I have always said to those close to me, Allah has indeed eased my affairs. We can plan as much as we like to get our way, but in the end, plan as we may, Allah is the ultimate determiner of our fate. I have had the opportunity to work with truly inspirational and brilliant minds, both at the international and local level. All the people that Allah has willed to put in my path have been really kind, helpful, and stellar. I leave you and the judiciary with no regrets. With that, I bid each and every one of you a warm and heartful farewell and a very happy 2025.
Thank you to the Right Honourable the Chief Justice of Malaysia. Honourable Judges, Your Excellencies, distinguished guests, ladies and gentlemen, we have now come to the end of the proceeding. The Malaysian Judiciary extends its deepest gratitude to all parties who have made this proceeding a successful one. Your Excellencies, distinguished guests, ladies and gentlemen, please remain in your position until the announcement to leave this hall is made. Please rise.
Announcing the departure of the Right Honourable Chief Justice of Malaysia, the Right Honourable President of the Court of Appeal, the Right Honourable Chief Judge of Malaya, the Right Honourable Chief Judge of Sabah and Sarawak. Of the Federal Courts.
Excellencies and distinguished guests seated at the front row. Honorable Judges of the Court of Appeal.
Honorable Judges of the High Court of Malaya and the High Court of Sabah and Sarawak.
Honorable Judicial Commissioners of the High Court of Malaya and the High Court of Sabah and Sarawak.
Chief Registrar and the Registrars of Courts.
Court orderlies. Ladies and gentlemen, you are now cordially invited for lunch at Putra Hall A concourse level. Thank you.